So yeah.
We're live on YouTube.
All right.
So that's got that going for us.
Sorry, I waited till we were about to start to put it on, but I have to, so.
Well, we were just having insignificant conversations. Just glad to talk to people.
Yeah, I feel you.
Do we have any idea who the new judge for the 95th is going to be?
It's Monica Purdy.
Oh, okay, wonderful.
She should be on any second.
No problem. So, Miss Deanna, do you find that you're able to process the docket more efficiently through Zoom than when you had people stacked up in the gallery, or?
Not on my end, because I didn't used to have to deal with that at all since I'm just a court reporter. So I'm setting them all now, but I'm used to the coordinator and clerks doing that. So kind of the opposite, but well, I get to work from home, so I can't complain.
Oh, you're at home.
Uh-huh. Yeah, I
Okay.
haven't worked up there since March. Can't believe it's been that long.
Wow.
Me neither.
I've maybe gone
neither.
up there twice for documents and stuff, but
Is then so the judge is at home too? Everybody is working from home at the courthouse?
no, she's on the bench and she's coming in right now.
Okay.
And the coordinator goes between home and the courthouse.
Okay, so like a lot of the law offices where you have people half-time at home and yeah, okay.
Damn.
Oh, I see her.
There she is. Morning, Your Honor, or afternoon, excuse me.
Good afternoon. How's everyone?
Well,
Doing
we're
fine,
doing
thank you.
we're doing good. We were just actually enjoying a little bit of small talk before you arrived because we haven't seen each other for a while.
Mhm.
And after the first month or so, you get stir crazy. And so you almost start to enjoy hearing so you can see your friends
Right.
and say
I
hi to them.
understand. Let me just bring up your case so I have the information I need. I know we're set today for a motion to compel, but give me one moment to bring it up. All right, I have it here. So we are on the record. This is cause number GC 20-11317, Raymond E. Stevens versus USMD Hospital at Fort Worth LP et al. May I have the parties announced on the record at this time? If you would let me know your name and who you represent.
Maria Wormington, represent plaintiffs.
All right.
Ryan Trammell, representing USMD Hospital of Fort Worth.
All right.
Greg Bird, representing USMD Holdings, Inc.
Okay.
Casey Cashin, representing Dr. Mike Martinez, U.S. Anesthesia Partners of Texas, PA.
All right. Thank you. Well, I am Judge Monica Purdy. I don't know that I've met everyone on this Zoom hearing. I'm the new judge of the 95th Civil District Court, so I'm going to be presiding over the hearing. I know that this is the plaintiff's motion to compel. Apparently, there's a privilege log at issue. Has there been a response filed to plaintiff's motion? I just want to make sure I don't overlook anything with respect to the hearing today.
Yes, Your Honor. We filed our response on December 3rd,
Okay.
and there's an affidavit attached to that as well.
All right. Are there any other responses? Okay,
No.
just them. All right. Well, I will let the plaintiff present her motion to compel at this time, and then I'll hear a response.
All right, very good, Judge. There are 3 documents at issue. Well, just by way of background, it's a medical malpractice case, and my client's wife died following a procedure in the defendant's hospital, and we properly sent out discovery, and they asserted privileges. We asked for a privilege log. They provided a privilege log, and there are 3 documents that are at issue on the privilege log: a peer review referral, a case review, and something called a notice of loss. I'm going to be addressing the first two documents in the first part of the argument and the second document in the second part because they involve different privileges.
Okay.
Now, defendants have the burden of proof to establish a privilege. We agree on this. Now, this can be done by affidavit or live testimony, and we agree on this. Now, in order for the peer review privilege to apply, and that is what they have asserted for the first two documents, the document at issue has to have been generated for a hospital committee that is set up in the hospital bylaws as well as its policies to perform peer review. We agree on this. Now, the issue is that defendants have failed to meet their burden of proof to establish that the peer review privilege applies to the first two documents, the peer review referral and the case review. They have submitted an affidavit from someone named Beverly Carpenter, and they have attached the hospital bylaws and a policy to that affidavit. That's Exhibit 4 to their response. And that's what I will be talking about, is the insufficiency of this affidavit. Now, the case law is very clear that in order to prove up the peer review privilege through an affidavit, the affidavit has to be descriptive enough to be persuasive. And in this regard, I would just point the court to the Arlington Memorial Hospital case. I'm sorry, this is the wrong one. And it does take a little while for my screen to come up.
Okay.
So I just need to know when the screen comes up.
I'll let you know once I see it.
Is it up?
It's up. I can see your files that you were choosing. I see a case.
Okay, very good. It's always a little bit challenging to be able to try to do it on Zoom because there is such a lag time. So it has to be descriptive enough to be persuasive. And in this case, nowhere does this affiant state or explain how she has knowledge of the peer review referral or the case review, which are the two documents at issue, how it was prepared, why it was prepared, or what specific committee it was prepared for. Now, if you look at her affidavit, page 83 of the bylaws discusses the medical executive committee, which is what she is purporting to talk about. And the medical executive committee in the bylaws states that it only consists of medical doctors who have medical staff voting rights. And I've got that up on the screen. I'm not sure if it's showing up.
Yes, I'm able to see the medical executive committee and the highlighted portion.
Right, shall consist, right, of the medical staff with voting rights. Now, she is not a medical doctor, so she is not on the medical executive committee. And so this is where it becomes problematic because she does not have personal knowledge to establish what was prepared for the medical executive committee because she's not on it and she doesn't say that she participates on it, so she can't know. Now, let's look at some of the case law where it talks about what is sufficient. And I'm going to start with that Arlington Memorial Hospital case that we were looking at a minute ago. This was an affidavit that was provided by the vice president of the hospital. Can you see the text, or is the tabs at the side hiding it?
Oh, I can see the text. It is
Okay.
highlighted with Harris's affidavit stated.
Right, that she attends and participates in the meetings of the peer review committee. Thus, she has personal knowledge of the statements made. And so contrast that to Beverly Carpenter's affidavit where she does not say anything of the kind. So we know that she's not a member. She doesn't say that she attends. She doesn't say that she participates. And so she's outside of what the case law establishes for us about what is required for the requisite knowledge. Another case that we can look at is the osteopathic hospital case. Just let me know when that one shows up. In this case, the affidavit was submitted by the chairman of the hospital's medical peer review committee. And based on his role as the chairman, he stated he had personal knowledge of what went on in the committee, et cetera, et cetera. Beverly Carpenter does not state that anywhere in her affidavit. And more importantly, nowhere does she explain how she knows who generated these documents, why they were generated, or more importantly, what they were used for. Now, the case law is really clear that just because a document passes through a committee does not make it privileged. It has to have been generated for and considered by that committee. And this affidavit does not meet the burden of showing that this affiant, Beverly Carpenter, knows that the documents we're talking about were generated for or submitted to the committee, because she's not on the committee. In fact, we don't even have a description in the affidavit of what her job is. She says that she is AVP of outcomes, but I do not know what that is. She does not say what that is. There's no job description. So we have no idea to know even if it's within her authority or her job description to do anything with these two documents. So the affidavit is just deficient to prove up the medical peer review privilege for those reasons. Now, the third document, the notice of loss, is subject to a different privilege. That one, the defendants have asserted the work product privilege. And the work product privilege, I mean, it can be between an attorney and a client, and that's not at issue here because there's no attorney and client. What she says is that when she received my letter of representation, she prepared a notice of loss to the insurance company. And so they are withholding it under the work product privilege. So let's look at the case law to see what that requires if you are going to claim work product privilege. And just so the court knows, my letter of representation was not the statutory notice of healthcare liability. It was simply I represent this person, please send me some medical records. And the reason why I sent that is because there's a very real issue in this case about the medical records that I was sent prior to litigation, because they are grossly different than the record set that was provided after litigation. So that's why we sent that letter of representation, trying to get complete records, because we knew the set they had given us wasn't complete. And I really tried very hard to get complete records. So that's why that was sent out, so we could evaluate it. Anyway, so if we look at the case called In Re York that I've got pulled up, it talks about what you have to show for the work product privilege. And so we'll just start. They pull it right out of the Texas rules, and there I have it highlighted what work product is. Now, what this case holds is, I'm not going to read the whole thing, is that in order to establish that your document comes within the protection of the work product privilege, you have to show that the individual had the authority to obtain professional legal services, to act for the client as to the legal service rendered, and to facilitate the rendition of legal services. And this case was a case of a car wreck. And so the insurance company's representative had obtained some documents. And so in the record, the affidavit by the insurance company representative showed that she had the authority to obtain professional legal services for this client, to act for the client on the legal advice rendered, and to facilitate legal services for that client. And then it cites a bunch of cases. And again, you can see that in the Arden case below, it's the same thing, that this case involved a witness statement. It has to have been obtained by somebody who had this authority. Now, looking at In Re Texas Health Resources, let me know if that's showing up on the screen.
Yes, it says lawyer-client privilege.
Right, okay, so looking at that, starting here on page 10 of the opinion, it starts with the analysis that we just went through, that the client's representative has to have had the authority for legal services. And this was the Ebola case that everyone remembers. And at issue in the case was whether investigation and notes that was obtained by someone who was not even an employee of the hospital could qualify for the work product privilege. And the court said, yes, if you can show through the evidence that that person is authorized to obtain legal services and act on behalf of that. And then there's some cases cited here. Now, this is because insurance companies typically have the duty to hire lawyers, which is why under the proper proof, non-lawyer communications can be qualified as the work product privilege. But we have to remember that there's no general privilege between insurance companies and their insureds. So it has to be under proper circumstances that communications between the insurer and their insureds are shielded from discovery. They're not automatically shielded. And what we've gone over in these cases is that the proper circumstances are when the affidavit shows that the individual has the authority to obtain professional services, to act on those legal advice rendered, and to facilitate the rendition of professional legal services. Now, the affidavit of Beverly Carpenter that they've submitted doesn't show that she had that authority on behalf of USMD Hospital. She doesn't say that anywhere, that that was part of her, authority and job description. So for that reason, it doesn't meet the strict test that is outlined in the case law to protect communications between an insured and an insurer that would otherwise be discoverable as, reasonably calculated to lead to the discovery of admissible evidence. So we're asking the court to order production of the Bates stamps 3, 4, 5 that are identified on the defendant's privilege log. I want to make sure that I've said all the Bates stamps correctly. It's in 1 and 2. So it's Bates stamps number 1 to 5.
1 through 5.
You
Okay.
can go back.
Response to that argument?
Thank you, Your Honor. Good afternoon. Ryan Trammell on behalf of USMD Hospital of Fort Worth. Thank you for giving us some time today. This is an important issue. The peer review privilege that's at issue in this case is a critical part of the hospital's function, because it's the legislature has recognized via the statutes that it's imperative for these hospitals to be able to give themselves a self-critical look and analyze themselves without the potential chilling effect of that information becoming public in the course of discovery or other means. So that's the issue that we're discussing here today. I agree with Ms. Warrington. We got separate privileges we got 3 documents, 2 privileges. 2 of the documents fit within the peer review context, and 1 of them fits within the work product context. So I just want to step back just a little bit first and talk about what the documents are. So the 2 peer review documents, there's a peer review referral document, and then an accompanying case review that went along with the peer review referral. And these were documents that were generated by the clinical VP of outcomes, Beverly Carpenter, who is part of the hospital's risk department. And she generated these documents for purposes of providing them to the medical executive committee of the hospital, which is the committee that's been given the authority pursuant to the hospital's bylaws to conduct the peer review analysis, the evaluation of the care that was rendered to the patients at the hospital. So that's what we're talking about in terms of the peer review documents. So the statutes that are at issue here, Judge, and I'm gonna do my best to not botch up the screen sharing here, that there are really 2 privileges that govern the hospital committee privileges. There is the medical peer review committee privilege, which is in section 160.007 of the Texas Occupations Code. And subsection A there reads that each proceeding or record of the medical peer review committee is confidential, and any communication made to a medical peer review committee is privileged. So we got documents that are produced by the medical peer review committee, and we have documents that are produced for the purposes of the review of the medical peer review committee, and both those types of documents fit within this privilege. So what is a medical peer review committee? That is also defined in the statutes. Texas Occupations Code 151.002A8 defines what a medical peer review committee is. And as you can see, a medical peer review committee is a committee of a healthcare entity, the governing board of a healthcare entity, or the medical staff of a healthcare entity that operates under written bylaws approved by the policymaking body or the governing board of the healthcare entity, and is authorized to evaluate the quality of medical and healthcare services or the competence of the physicians, including the evaluation of the performance of those functions specified by Section 85.204. So if you have a committee that meets that definition, and then you have a document that meets one of these two categories of documents produced by that committee or produced for that committee, then you have a document that is protected by the medical peer review committee privilege. And this is an area of law that's well developed. The NRA osteopathic medicine case that Ms. Wormington cited is an excellent case in that it really shows the step-by-step guide of what these affidavits generally look like. Agree with Ms. Wormington, it is my burden to establish the applicability of the privilege. If I make a prima facie case that the privilege applies, then the burden would shift to the plaintiff to demonstrate some exception to the privilege. And that NRA osteopathic medicine case, just so you know, Your Honor, it was a case where the hospital had developed this patient quality event tracking report. Some employees had created these tracking reports for purposes of providing them to a hospital committee. And the affidavit stated that the incident report that they were trying to protect was prepared for that quality assurance committee. It was not made in the ordinary course of business, and it was not part of the patient's ordinary medical records. And because it met those criteria, it was a document that was protected by the privilege. That case also makes a distinction with a document that was not created for purposes of the medical peer review process. It was a document that was generated by the security team following the slip and fall incident. And because that document was not developed in furtherance of this quality analysis, it was not protected by the privilege. So the fact that the document is generated for purposes of review of quality healthcare evaluation is really the critical piece. The second privilege that applies is found in the Texas Health and Safety Code, and it's called the medical committee privilege. So it's a little bit, it's very much similar, but it's a little bit broader. Section 161.032 of the Texas Health and Safety Code. Subsection A says the records and proceedings of a medical committee are confidential and are not subject to court subpoena. Medical committee is defined broadly in Section 161.031 as any committee, including a joint committee of a hospital. So very, very broad, whereas the medical peer review committee definition is a bit narrower because there's that language about it having to be part of something authorized by the bylaws and that kind of thing. So it's very similar in its application. There's a case called NRA Christus Health Southeast Texas out of Beaumont that guides our analysis very similarly to the osteopathic medicine case, but as applied to the medical committee privilege that's laid out in Section 132. And we see very much the same type of analysis where in this case, there was not a medical doctor that filled out the affidavit. It was just the hospital's manager of risk safety that completed the affidavit in that case, which is a very similar type position to what Ms. Carpenter has. And in that case, the plaintiff was seeking to obtain variance reports that had been created for a safety committee that the hospital had created. And the court said because those documents had been developed for purposes of providing them to the safety committee so that the safety committee could look at them, analyze the quality of the care, those documents were protected and privileged. So very similar type analysis. It's just a little bit of a broader privilege. And we both think that they apply in this case today. So let's look at the evidence that we actually have here that we provided for the court. And it is Exhibit 4 to our response. It starts on PDF page 36, if that helps. It's a rather lengthy document combined. And the affidavit goes into quite a bit of detail about what these documents are. So it seemed to me that Ms. Wormington was raising the issue that Ms. Carpenter had to be a medical doctor or state that she was a member of the committee or something to that effect. I'm not aware of any law that states that as a requirement. Those cases she cited, I did see that those people that filled out those affidavits happened to be on the committee, but in this In Re Christus Health case, it does not say that the affiant was a member of that committee. So I'm not aware of a requirement of that. I don't know if Ms. Carpenter was or was not, to be quite candid with the court, but I'm not aware of a requirement. What Ms. Carpenter does say is that she was the vice president of outcomes, the AVP of outcomes at the time of the care in question. It was her job to gather this information and provide it to the medical executive committee. So it was she that crafted these documents, and it was her job to gather that information for purposes of providing it to the medical executive committee. She states that she has personal knowledge of the medical executive committee by virtue of her work with the medical executive committee. In paragraph 2, by virtue of my work with the medical executive committee, I'm familiar with the Texas Medical Peer Review Committee and Hospital Medical Peer Review Committee statutes, including the confidentiality provisions. She's familiar with the bylaws that outline what the medical executive committee does. She attached them to her affidavit. So she was very familiar with this process because she was integral to the process. As far as whether or not this committee fits into the privilege, she attached the bylaws, which, as Ms. Wormington stated, specifically says that the medical executive committee was charged with undergoing this quality evaluation process. So if you look at base label page 661, which is page 86 of the bylaws, base label page 661. The quality improvement function will be conducted by the medical executive committee or ad hoc committees assigned by the chief of staff. The purpose of the committee shall be to ensure and oversee the existence of an ongoing quality improvement program at the hospital designed to objectively and systematically monitor and evaluate the quality and appropriateness of patient care, pursue opportunities to improve patient care, and resolve identified problems. Then it goes on to specifically outline some of the duties of this committee, which include a review of cases of patients requiring hospitalization following treatment at the hospital. It includes evaluation of the quality, clarity, and completeness of medical record entries, evaluation of clinic performance. So this committee was authorized by the bylaws to conduct this quality evaluation process. She states that in her affidavit. So that's the evidence that we have that the medical executive committee was the type of committee that fits within both the medical committee definition and the medical peer review committee definition. Then she says, it goes on to say, in outlining each document, the quality management referral document, which is the peer review document, and the case review document, which is item B here, that the referral was created for the medical executive committee's investigation and deliberative processes in evaluating the quality of the medical and healthcare services provided at USMD Hospital in connection with the unanticipated patient outcome. She states that these documents were kept separate and apart from the patient's charts. They were not ordinary course of business records that are just thrown into a patient's chart. They were created for purposes of providing them to the committee following this unexpected patient outcome. And the same is true for the case review document, which is the document that accompanies the peer review referral document. It was not part of the ordinary course of business, not part of the patient's records, and was created for the confidential peer review process. So we think that this affidavit, which is highly detailed, which goes into how the committee was created, how the committee works, and that these documents were created for purposes of providing them to the committee so that it can conduct this evaluation process. We think that it fits within both the medical committee and the medical peer review committee privileges. In addition to the information that Ms. Wormington raised about that there needing to be personal knowledge of the committee by virtue of being on the committee, I'm not aware, like I said, of any requirement of that. She says she has personal knowledge of the information contained within the affidavit, which is generally considered to be sufficient for someone to author an affidavit. And she includes that information in paragraph 1. She also includes in paragraph 2 her position and by virtue of that position, her familiarity with both the bylaws and the evaluative process, the peer review process, which is also laid out in a policy that she attached to her affidavit. So she's intimately involved with this entire process. As far as the document that was created following the notification by Ms. Wormington's firm that they were investigating the claims, we believe that document fits squarely within the work product privilege. And I've not reviewed the cases that Ms. Wormington cited, but I did seem to notice that that last case she was citing appeared to be referencing the lawyer-client privilege, the attorney-client privilege, which is a different privilege than the work product privilege that's laid out in section 192.5, rule 192.5, the Texas Rules of Civil Procedure. So Texas Rule of Civil Procedure 192.5 states that work product comprises a communication made in anticipation of litigation or for trial between a party and the party's representatives or among a party's representatives, and then goes on to define party representatives as including employees and insurers. They're both specifically listed in 192.5B as persons that are considered to be parties' representatives. Communications among party representatives are protected as long as there is anticipation of litigation. And as Ms. Wormington stated, we have that test, that two-part test that's laid out in the National Tank case that states there needs to be an objective, reasonable person type standard of would a reasonable person anticipate litigation in this situation, and then a subjective belief by the person that there actually could be a substantial chance of litigation. So what is our evidence that proves up the application of that privilege? In Ms. Carpenter's affidavit, in section 7, she states that she received the letter from Ms. Wormington's firm on or about December 2nd. The letter's dated December 2nd of 2019, so she may have gotten it a day or two after that. But upon receipt of that letter, she drafted this notification to the liability insurance carrier because she came to the conclusion the litigation was likely going to ensue. Now, that In re Christus Health Southeast Texas case that we were referencing earlier also discusses this work product privilege. And interestingly, the court uses the receipt of a notice letter kind of as the anchor to which they determined that there was reasonable anticipation of litigation. And that is right here at the top of this page. Christus received the notice on November 17, 2004. And there's another letter, and the investigation report that was at issue was prepared 6 months after the notice letter and 1 month before the plaintiff filed suit, was prepared in anticipation of litigation as contemplated by 192.5. So that notice letter is important because it is recognized by the case law as kind of an objective measure that a reasonable person, if they get a letter from a lawyer saying I'm investigating a claim against you, a reasonable person can anticipate the litigation is going to ensue. And then we also have the information in the affidavit in which she says, I in fact anticipated the litigation myself, subjectively. So we think both elements of that anticipation of litigation test are met by the affidavit, and we believe that document should be protected as well. So, Your Honor, for those reasons, we believe that the first two documents, both the peer review referral document and the case review document, which are prepared solely for the purpose of the clinical evaluation of the care by the medical executive committee is protected. And we believe that the insurance notification is also protected because of the timing and purpose that that document was sent.
All right, counsel, brief response.
What Ryan says may be true, but the affidavit doesn't say it. Nowhere does Beverly Carpenter say that she generated these documents, the peer review documents that we're talking about. I don't know where they came from. The record is naked as far as I can tell, as far as where those two documents came from. Nowhere in her affidavit does it say it was her job to generate these type of documents. So I don't know why she thinks she has personal knowledge of why the documents were generated and to whom they were sent, because she doesn't say it in her affidavit. And that's important because that's their burden. And just on the face of this affidavit, the proof is not there. It doesn't say, Ryan said it says she crafted these documents, but I don't see it in the affidavit. I would also point out that as to the notice of loss letter that they're claiming privilege on, the letter of representation that I sent does not say I'm investigating claims against them. So I wouldn't think it would be reasonable to think that litigation is imminent because you have an anesthesiologist, you have probably a CRNA, you have any number of people who are involved. And so until the statutory notice of healthcare liability claim letter goes out, I don't think it would be reasonable to anticipate litigation at all, because I'm asking for medical and billing records. And obviously you need that so you can do an investigation. But anyways, regardless, she hasn't established that she has the authority in her affidavit to facilitate legal services. And I think that you need to do that in order to qualify for a work product privilege. Otherwise, you're just sitting in the general pool of documents that are discoverable, because there's no privilege between an insurer and its insured unless you can show those extra steps.
Counsel for the plaintiff, have you taken a look at that case that was mentioned, the N. Ray Christus case? I have not, but I'm interested in seeing how you think that case may be distinguishable from the facts that we have here today.
Are you speaking in terms of the reference to the notice letter?
The notice letter, as well as I believe they mentioned something about whether or not you had to be a part of the committee or whether or not you had to prepare something that was going to the committee. Like I said, I haven't looked at the case. I plan on looking at the case before I issue a ruling, but that was of interest to me.
Okay, I don't have it in front of me. My recollection of that case is that it was the statutory healthcare liability claim notice letter that they were talking about. And then as far as being a member of the committee, I don't know if the case focused on that at all. I don't know if the objection was raised by whoever they were talking about. I don't know if the affidavit at issue in that case said, I prepared these documents for the committee, somehow establishing why the person would have personal knowledge. And I think you have to have that. If you're not part of the committee, you can't have personal knowledge of what goes on in the committee. But maybe your job is to prepare documents for the committee.
All right.
Neither of those things are in this affidavit. Now, the N. Ray Christus case, I'd have to look to see if anybody focused on that analysis at all.
All right, Mr. Trammell, I'm going to ask the same question of you. And I'm also at the conclusion of this particular hearing going to ask you to send me a courtesy copy of that case. But
Absolutely.
I'll ask those same questions to you.
Sure. So, as far as the N. Ray Christus case, I do think it's important because, as I said earlier, I'm not aware of any case that specifically says someone has to be on the committee. The idea is that documents that are generated by or for a committee are protected. So the idea that someone could generate something for the committee requires them to be on the committee is not true. Anyone that if the committee calls someone and says we need some information and that person does not happen to be on the committee and that information is provided, that information is protected pursuant to the language of the case law and the statutes because it is something that is provided for the committee. So I think that's an important point. Also, I think the court can just look at the letter that was sent with respect to the issue of the notice letter I can share it for the court right now. It's attached to Ms. Carpenter's affidavit. And it says, please be advised that my client, Raven Stevens, has retained this firm to represent his wife's estate regarding claims stemming from the outpatient surgery performed on 10/29/19. So the implication there is that there is representation, there are claims, and that is enough to give a reasonable person the idea that there might be some litigation on the way. So whether it usually uses the word investigate or not, I don't see that word, but we have claims, we have representation on behalf of the estate, and that is sufficient in order to give a reasonable person notice that they get a letter. I think 99% of people, if they get a letter like that, are going to be somewhat concerned that they're going to be embroiled in some sort of litigation. So that's attached to the response, and the court can review that as well. The bottom line is that when there are documents that are created for a committee, then that document is protected. If the court is concerned, I think the affidavit is clear that she has knowledge of these documents. But if the court is concerned that it's unclear and that the court doesn't know whether Ms. Carpenter drafted them or not, I'm happy to get a supplemental affidavit from Ms. Carpenter that says that she did, if that would eliminate any doubt in the court's mind. But I think the affidavit is clear with respect to her personal knowledge of the process and of these particular documents.
All right. Counsel for the plaintiff, do you have any final words you'd like to offer with respect to the motion that's before the court?
I'm just looking at the In re Christus case, and I don't see that they address the issues that the court was concerned about in terms of whether or not that person established personal knowledge. It just doesn't even look like it was an issue. So I guess it was something that was evident from the face of the affidavit, how that particular individual had personal knowledge of the generation of the documents is my reading of the case. It just doesn't seem to be instructive at all.
Yeah, Judge, that's kind of my point, is that if that was an element, something that had to be in there, it probably would have been identified by the court, is my thought. I've never seen any case that specifically says, and the plaintiff has not cited any case that specifically says that there has to be someone that was on the committee in order for
well, and to be clear, that's not my argument. My argument is you have to establish by the affidavit as part of your burden of proof how you know what you say you know. And there's two ways to do it. We've seen the case law where they said, okay, you're on the committee, you know. And then if you actually are the one who prepares the documents for the committee as part of your job description, that's another way that you might know. But this affidavit doesn't say either of those things. It doesn't say she prepared those documents. We don't know where they came from. And so we don't know how she knows what she says she knows. And that's just basic black letter law, that if it's your burden of proof, you have to establish, how you know what you say the truth is. That's all.
All right. Are there orders uploaded to the court with respect to the motion that is before us today?
Judge, if there's not, I'll
Certainly
make sure there
should
is
be.
one.
Okay. I don't see an order with respect. I see the response. I see the motion to compel that was filed, but I don't see any respective orders. Counsel for the
Make sure that
plaintiff,
happens.
do you know if you uploaded an order? I'm trying to look through that.
I don't.
I don't know. Off the top of my head, I can't access my VPN to check that because I'm using
Okay.
all my internet for the YouTube, but certainly we will submit a proposed order.
All right. Well, I'm just doing a quick perusal of our files here. I don't show one, so I'm going to ask both of you all to upload an order with respect to the hearing that we've just had. When we go off the record at the conclusion of this hearing, I will give you my email address as a courtesy to just send me a courtesy copy of your order that you have e-filed, in addition to the case that was referenced in this particular hearing. I am going to attempt to have a response to you all by tomorrow. The way that you will know how I ruled on this particular matter is I will sign a particular order, enter it in the court's file, and push out a copy to you all via email. All right. Is there anything further before we conclude this hearing and go off the record? Because I'm going to give you my email address and I didn't want it to be a part of the record.
Did you want all the cases that I referenced, or are you speaking really just regard to the In re Christus case to Mr. Trammell?
If you have some cases that you think are persuasive to the argument that you've made, if you'll just send those as a courtesy to the court, copy Mr. Trammell on that. I'm happy to review those before I make an order.
Okay, thank you very much.
Okay. All right. That concludes our hearing. We'll go